Thanks very much, Renee. And good afternoon to all of you. I'm really pleased to be joining you this afternoon for this webinar, and I'm thrilled to be stepping into the notably big shoes that Renee has to continue OpenSky's tradition of insightful and timely policy analysis. And I think we are just really well positioned this afternoon to be having this conversation about the Constitutional Convention. And it's really important for us to be able to understand what this issue is and what the implications are for folks here in the state of Nebraska. So I'm looking forward to insightful analysis and dialogue by the experts we have with us today, and grateful that all of you are joining us. So back over to Renee.
Great, thanks so much, Rebecca. And today we are grateful to have David Super, a Georgetown law professor who specializes in constitutional law, and Judi Keller, the Article 5 Issues Director for Eagle Forum of California, to talk about LR 14, which is a legislative proposal that would have Nebraska join a list of states calling for an Article 5 convention that would likely be debated by the Nebraska legislature next week. There's a lot of misinformation about what an Article 5 convention would mean, so we really appreciate having these experts provide some background and insight. Some housekeeping notes before we begin. Today's webinar is being recorded. A video of the webinar will be distributed on our listserv and will be posted on our website in the coming days. Attendees will be on mute the entire time. If you have any questions, please type them in the Q&A box at the bottom of your screen. Please try to limit your questions to 2, which will make it easier for us to monitor and will allow as many people as possible the opportunity to ask questions. And we will do our best to get as many questions answered as possible. So I just want to start out with a little bit of background on some polling that has been done around this issue. National polling conducted early last year actually demonstrates strong public opposition to a constitutional convention, particularly among Republican voters. 47% of all voters opposed an Article 5 convention, with 35% in support and 19% unsure. But after being presented with arguments for and against a convention, 55% of voters said that they were opposed to the idea, with only 31% still saying they support it. And opposition was even higher among Republicans. Nebraskans are even more opposed to a convention. In early 2021, a survey of likely voters in Nebraska asked if they would support or oppose a national constitutional convention to add amendments to the US Constitution. 60% of those surveyed were in opposition, with 47% in strong opposition. In contrast, 31% expressed support and only 9% said that they were strongly in support of the idea. So what we see in this polling and what we see when we talk with senators and others is that as people learn more about what an Article 5 convention really is and what it could mean, people start to sour in the idea. And so we thought that this was a real opportunity to bring in a couple of experts on this topic to really flesh out what we're talking about here with this LR 14 that will be up for debate next week. So we'll go ahead and get started. So I'll start with you, David. Thanks for being here. Proponents want to call an Article 5 convention. Can you explain to us what that is?
Certainly. Article 5 of the U.S. Constitution provides for 2 separate ways of amending the Constitution. One of them, which we've used 27 times, involves Congress by 2/3 vote of both chambers sending proposed amendments to the states for their ratification or rejection. The other, which we've never used, is for 2/3 of the states to apply to Congress to call a new convention. The convention would then be able to propose any amendments that it wanted to, up to and including a complete rewrite of the Constitution. That's what's being proposed here.
Great, and thank you, Judi, for being here today as well. Did you have anything that you wanted to add to this?
Well, the Convention of States Project, who's leading the fight for LR 14, didn't invent the term Convention of States, but they made up the definition for it, and it's a myth. By their definition, the convention can't run away because the delegates have to obey the application, which is the resolution you're voting on. They're waging a semantics war. It is a constitutional convention because Article 5 is a federal convention called by the federal government for the federal purpose of amending the federal constitution. It isn't a state function, and our Constitution doesn't provide for it to be a state function. We're talking about the same thing, whatever we call it.
Great, thank you. So David, is there, and I think Judi just touched on this, but is there a difference between a convention of states and a constitutional convention?
There's not. The proponents keep insisting that they're not proposing constitutional convention, but it's a convention and it relates to the Constitution. So I don't know how that wouldn't be a constitutional convention. The Constitution itself doesn't use either term. It speaks of a convention for the purpose of proposing amendments. But that is a very powerful thing, and there are no restrictions on how sweeping those amendments could be. And again, as I'm sure happens from time to time in your legislature, sometimes someone will propose an amendment that is to strike everything after the enacting clause and insert something wholly different, and they could do that as well.
Judi, anything you wanted to add?
I think that's good.
Okay. So Judi, can you tell us more about LR 14 and the Article 5 convention movement and what they're hoping to accomplish?
Sure. LR 14 in Nebraska is not unique. It's being introduced all over the country in just about every state. It is Nebraska's application to Congress asking to be counted as one of the 34 states under Article 5 of the US Constitution for the ostensible purpose of imposing fiscal restraints on the federal government, limiting the power and jurisdiction of the federal government, and limiting the terms of office for its officials and members of Congress. However, the purpose stated in the application doesn't matter. It is bait. The purpose is bait to get the legislators' vote on the application. But just that one subject, limiting the power and jurisdiction of the federal government, even if it could limit the convention and the delegates, which it can't, it targets the bulk of the Constitution. And the sponsoring organization of LR 14 is the Convention of States Project. Its president and lobbyist is Mark Meckler. There are four main organizations pushing the applications for an Article 5 convention, ostensibly on their pet subjects, COS, Convention of States, and besides them, the balanced budget amendment groups, the UST term limits, which is for term limits for Congress, and from the radical left, Wolfpack, whose ostensible purpose is to take money out of politics and overturn the Citizens United decision. Plus, there's one more, the newest bait in the game is the ostensible purpose of limiting the Supreme Court to 9 justices. So, and Convention of States, since it's so broad, it appears to go with any subject that's palatable enough at the time to get the legislators' votes, because it is broad. So if it's April 15th, they'll cut your taxes, and they've said that on April 15th. But the convention has no limits once it convenes. And the groups tell legislators that they're trying to pass the same application in 34 states, each on their pet subjects, so that Congress must call a limited convention under Article 5, but a limited convention doesn't exist. And as to what they hope to accomplish, I don't know what's in their minds. I can't comment on that.
Great, thank you, Judi. David, I don't think you had anything on this one, so I'll go to the next unless you want to step in. So David, how many states are required to call a convention, and how far away are we from one? I mean, so I get this question all the time when I talk to senators, and they're like, this could never really happen. I mean, we aren't that close. So can you speak to that a little bit?
Certainly. The Constitution requires 2/3 of the states to apply before a convention is called by Congress. That's 34 states in our country as it stands today. The groups supporting a convention who claim that it'll give us a balanced budget amendment say they have 27 states. I think there's a little funny math there, but they say they have 27 states. But there also have started counting other states' very old applications for conventions for completely different purposes, as if they could be brought in together. For example, Washington and Oregon have not signed on to the balanced budget amendment or Convention of States proposals, but they did pass applications early in the 20th century wanting the popular election of senators. Illinois and Kentucky have not signed on to these current movements, but they did in 1861 ask for a Article 5 convention to avoid the Civil War. And New York has not signed on to any of these things, but in 1789, they asked for a convention to write a Bill of Rights. These groups are proposing to count these 5 other states that want nothing to do with their agenda to get to 34. And if they have sympathetic people in charge of Congress, they will be able to do that. That means that if you take their 27, add the 5, that they're at 32, and really quite close.
Thanks, David. Judi, did you have anything you wanted to add here?
Yes, the convention lobby has been telling us for years that the applications need to be the same in order to be counted toward 34 on the same subject. The convention lobby, that's all of the groups, has been telling legislators, let's say, what they say is false, that's false. But saying that bolsters their false claim that delegates to a convention are limited to the subject of the application, because what would they be limited to if all the applications were different? The truth is that Congress has the power to count and judge the applications however they wish under the necessary and proper clause. Congress has the power to aggregate all the applications ever filed, which are unrescinded. So because legislators' greatest fear has been that the convention will run away, proponents made up the false narrative to give legislators a false sense of security so that they'll vote for the applications. But now what's happening, and we're not guessing, strategists have written this. In 2020, there's an article from someone led by someone who used to work for the Convention of States, and there's a BBA person that contributed, that said, hey, we've plateaued. These applications, they're not passing very easily. Legislators are getting really tired of them. We have states rescinding. There's more and more, and there will be more and more, and we're not going to get to 34 anytime soon. But the people aren't disgusted with what's going on with politics in the country. We have to do something now. Timing is everything. A bird in the hand. So let's gather the applications we have and put them all together. And that's what they're doing. But when they do that and they put them all together, they've contradicted the narrative that the lobbyists have been telling legislators for years, that they all have to be the same. So the lobbyists interfacing with the legislators say the convention has to stick to that subject to get their votes. And on the other hand, they're telling their own side that in order to get a convention while we still can, we need to be really creative in counting to 34. So what we're looking at is a public relations campaign. They don't want more than 33 states right now, although they can gather more, but they want 33 because they need a big public celebration saying, we did it, we've got it. That could happen in South Carolina because it's a new state, no applications there. So they could say we're at 34. They can't very well say, hey, we just noticed that we got our 34th state in 2017. That's not going to go over very well. So we're looking at a public relations campaign here to convince people, the legislature and Congress, that the people are demanding a convention. The campaign features, I have details for this I could provide, phony petitions, misleading polls, and inflating the size of their so-called army. The campaign has nothing to do with each group having to reach 34. It's a narrative that everyone's been sold up until now. It has all to do with timing, to take advantage of the mood of the people, which is we have to do something. The PR campaign influences legislators' votes. Some legislators who fear a convention vote for the applications because they think, we're only 1 in 34 states. We'll never get there. We're just going to put a little pressure on Congress and they'll propose amendments, the safe method. But the aggregation theory of mixing and matching applications shows that a convention could be called in 2022.
Wow. Yeah, a lot of what you said resonate with conversations we've been having with senators about, in particular, again, we're not going to get to this. This isn't going to happen. We're frustrated with Congress. We have to do something. So maybe we can talk about that a little bit more. So David, in your legal opinion, can a constitutional convention be limited in scope once it's called?
No, it cannot. And the groups that insist that it can are unable to point either to any legal authority for that limit or any body that has the power to impose a limit if there were one. You can read Article 5 of the Constitution. It's very short, plain language, easy enough to read. There's nothing in there about a limited convention. There's nothing in there empowering Congress to impose limits on the subject matter of a convention. There's nothing in there empowering states to impose limits. There's also nothing in there empowering states to choose the delegates or to control the delegates that do go in. So this will not be a convention of the states. This will be a convention of whoever Congress decides will be the delegates. They could ask the states to pick. They could pick themselves, or they could pick somebody else. So the states can't control it. Congress can't control it. The president has no role in this at all. And there's nothing in the Constitution that imposes limits that the courts could step in on. Even if there were limits, there's nobody that has the power to do anything. By design, the Constitution does not allow Congress to overrule a convention. The whole argument that proponents make for a convention is that we don't trust Congress. You can't, they say, well, we don't trust Congress, but they're going to make sure this doesn't run away. That makes no sense. Again, the president has no role in this. The Supreme Court has held that these are political questions, and the courts can't get involved, and the states have no authority. So once it's convened, the convention can do as it pleases. The only precedent for this is the convention in Philadelphia in 1787. That convention was called for the limited purpose of proposing amendments to the Articles of Confederation, supposedly what this convention would be. They immediately chucked that instruction in the trash and set about writing an entirely new and very, very different constitution. They also threw out the ratification rules in the Articles of Confederation and came up with their own new ratification rules. We're concerned a new convention will do just that. And there's nothing in law anywhere that says that they are restrained or that lets anyone restrain them.
So David, you're one legal scholar. What's the consensus on this issue about the ability to limit an Article 5 convention?
There are people who say if the convention wanted to be limited, it could be, which is certainly true, but there's no one that has pointed to any legal authority that would allow a convention to be restricted, or anyone who could enforce that authority. So I think the consensus is fairly clear that unless the convention chose to restrain itself, we do not live in times where people with political power show a lot of self-restraint, then the convention is off to the races as soon as it convenes.
Judi, did you have anything to add to this question, or?
Yes.
Okay.
So the proponents look, generally just at the Constitution, but we have another founding document that they miss, and that's the Declaration of Independence. The convention delegates, as sovereign representatives of the people, have the inherent right, as expressed in the Declaration of Independence, paragraph 2, to alter or to abolish their form of government. And that's what they did, as David said, in 1787. In Federalist 40, which is the 15th paragraph, James Madison invoked that transcendent and precious right of a people to throw off one government and set up another one as justification for those delegates in 1787 ignoring the instructions, because they had that right. And they wrote as David said, a new and easier ratification process to go along with it, and it can happen again. Neither Congress nor state legislatures have any authority or control over a convention once it's called to order. Convention of States testifies that state legislators can text message their delegates and tell them what to do at the convention, and that they're just like insurance agents under agency law. That is absurd.
Okay. Thank you both. So David, you mentioned delegates. Can you tell us how the delegates will be chosen?
There's nothing in the Constitution that says anything about that. All we see in the Constitution is that if 34 states apply, Congress will call a convention. In the course of doing that, Congress can choose the delegates, or it can set up a process for choosing the delegates. It can decide how many delegates that there will be allocated to the states. It could, for example, provide a one person, one vote approach. It could say that there will be one delegate or three delegates for groups of states. Perhaps Nebraska and the Dakotas could have one delegate together, and then some of the larger states would each have individual delegates. There are no restrictions at all on how this will be done. The proponents of this typically talk as if it'll be one state, one vote, which is possible, but by no means required. There's nothing in Article 5 that constrains that. And if I were in a small state and was concerned about how this would come down, the large states dominate the House of Representatives, and I would not assume that they would be willing to give equal vote to the smaller states.
Okay, thank you. Judi, anything you wanted to add?
No, thanks.
Okay. So Judi, several senators point to our national debt as a reason we need to amend the Constitution. How do you respond to that argument?
Well, there's certainly merit to limiting the national debt. But that being said, the problem is that there's no way to limit a convention just to the subject of the application. It isn't worth the risk. You're putting our entire Constitution and our freedoms at risk by going through the convention process. Once we ring the bell, we can't unring it.
Okay, thank you. David, did you have anything on that question that you wanted to add?
Well, I would just point out that many of the concerns that have been raised about fiscal matters and the scope of the federal government allege that Congress has not been following, or the federal government has not been following, our existing Constitution. If they can disregard the current Constitution, they can disregard any new one that might be proposed out of a convention. If you think the problem is that they're not doing what they've already been told to do, then the effort needs to be to get them to comply with that, rather than throwing open our entire Constitution in the hopes that somehow writing, well, we mean it, into this or that constitutional provision will actually make a difference.
Okay, thank you. So David, if a convention were called, what kind of representation should Nebraska expect to have? I know you touched on this, but maybe you can say a little bit more. And who would the delegates be? Again, you touched on that, but maybe just reiterate how that looks and what special interest groups, would special interest groups, excuse me, have any influence on the outcome?
Well, I think it's anybody's guess what sort of representation Nebraska would have. On that, again, this would need to be passed by both the House and the Senate, and the House is overwhelmingly filled with representatives from the larger states. One would imagine that they would want some degree of proportional power for the larger states in any constitution, and would arrange for delegates to be allocated accordingly. If indeed it's entirely possible that they would simply declare that the House of Representatives is the convention, that they would make all of the House members, or all House members and senators, the delegates to such a convention. There's nothing in Article 5 that says that couldn't be done. You could imagine a version of Article 5 in which it really was a process controlled by the states, but that's not what the framers gave us, and that's not what we have in Article 5. So you could have pretty much anyone that Congress thought was appropriate, and you can imagine that this could be somewhat partisan, depending on who's controlling Congress at the time the convention is called, that you could have the delegate selection skewed this way or that way, as we tend to do these days. The other thing you asked about special interest, we have limited laws. I think many people would agree they are not adequate, restricting corruption in politics and the use of money to swing votes. those are mostly written for legislatures and for elections. This convention is something entirely different, and a great many of the things happening in this convention would not be covered by those laws. So things you can't do for your legislature, things you can't do for an election, would be perfectly legal to do to influence this convention. And as Judi indicated when she was running down the list of the proponents of an Article 5 convention, these are all interest groups. These are groups that are hoping to hit the policy jackpot and write their wishes into the Constitution for generations to come. They're not going to back away. And this indeed was the biggest concern that the late Chief Justice Burger raised when he said that he was opposed to an Article 5 convention, felt that it would be completely overrun with unregulated special interest groups, money groups, and that we would end up with a constitution that would reflect their interests rather than those of the people.
Judi, I think you had something you wanted to say on this question.
Well, there's already a lot of pressure, and there's tens of millions of dollars being spent by the convention lobby, probably from each group, just to get this application through the legislatures. Think about what would happen if we actually had a convention. In that same article I was talking about, it's called A Convention Strategy by the Strategists Talking to Their Own Groups, suggests, in addition to mixing and matching those applications to trigger a convention in 2022, he's recommending that the convention lobby, among other things, needs to, quote, provide the states with logistical support from the pre-convention all the way through ratification, including facilities, security, communications, media, and legal support. What? Their job isn't done after spending tens of millions of dollars just to get 34 states passing applications. How much will this cost, and whose agenda will they be pushing? They've been known to say, oh, this is just a suggestions convention.
Okay, thanks, Judi. Judi, what are some of the constitutional amendments or current constitutional amendments that could be changed if a convention's called?
Well, our Constitution mentions our rights, our God-given rights. We could lose our entire Constitution. We could lose our Second Amendment, our First Amendment, Fourth Amendment, any amendment. The 14th Amendment, which is important to Black citizens who didn't have their rights recognized from day one like whites did. They needed the 14th Amendment came along and did that. We could have a tyrannical constitution with a new and easy ratification process imposed on us. The ratification process could be like there's one constitution, a national referendum, which is a national popular vote where whoever controls the machines controls the votes.
So some conservatives say that actions by Congress have given us no choice but to call a convention. In fact, I heard this when talking to a senator just today. Judi, what do you think of that argument? Oop, you're on mute.
Sorry. I agree that the national government has acted horribly and they're usurping their powers for sure. But an Article 5 convention is a solution that has nothing to do with the problem. Things could be worse, believe it or not. This could make the situation really worse. The easiest way to get a new constitution, short of a hostile takeover, is through an Article 5 convention. At least we still have the document, even if the federal government isn't obeying it. We could always dust it off and use it if it hasn't been replaced.
So can we be confident, I think you've already answered this, but can you be confident that any bad amendments won't get ratified, David?
Unfortunately, we can't for several reasons. One is that the only precedent to this, the Philadelphia Convention in 1787, disregarded the ratification procedures that were set up. There were two key points of the ratification procedures on the Articles of Confederation. They were handled by state legislatures and they had to be unanimous among all the states. The convention in Philadelphia bypassed the state legislatures and called for state ratification conventions. And they said that only 2/3 of the states would be needed to approve the initial constitution. There were a number of states that were clearly not going to support it, that were strongly opposed to the new constitution, certainly Rhode Island, North Carolina, probably New York. But after the new ratification procedure was imposed and they got they got the 2/3, those states accepted a constitution that they didn't like. The same thing could happen again. They could set up a national referendum, as Judi says, and say, well, we didn't have the technology for that back in the 1780s, but now we do, so we're going to do it this way. And in which case, it comes down to who's got the most money for advertising, for sound bites. You could easily see things getting packaged together that have nothing to do with one another. There are 8 different ideas in the 14th Amendment. You could imagine a package of amendments that involves doing something on guns, doing something on the First Amendment, doing something on a balanced budget, doing something on various other things, all wrapped into one package, and with a slick advertising campaign getting approved. The other thing about it that's so scary is that although there are procedures under the Constitution for amending it to remove actual amendments that are in it, there are no procedures for eliminating proposed amendments. They would be lingering out there waiting for some opportunist to come along and do it. So even if they stick by the existing ratification procedures, and they get maybe 30 states right away and they're 8 states short, it'll be lingering out there for who knows how long until someone comes along and has a wave election, picks up some more states and gets it in there. There's no way to close the book on it. A few times Congress has said we won't allow an amendment to go into effect if it isn't ratified within so many years, but there's nothing requiring the convention to do that. And given, as Judi says, the enormous amount of money they're putting into getting this convention held, it's hard to imagine that they would undermine their own work by putting a deadline. So if we get a bad set of amendments proposed, they'll be hanging like a sword over the Republic for all time.
So you answered this sort of indirectly, but I think it's an important point. So could the rules be changed so that it's 25 states could ratify?
Absolutely. Again, there's no one that has the power to constrain that. The Supreme Court has said the process of ratifying, proposing and ratifying changes to the Constitution is a political question that the courts cannot get involved in. It's a federal matter, as Judi says, so state courts aren't going to be able to get involved in that. So yes, they could change that. What they did in 1787 was said that 2/3 of the states would be needed to ratify it, and then it would be binding on those states. You can imagine something like that now, where they say a majority can ratify this, and when they do, it's binding on those states. And the other states, just like Rhode Island and North Carolina in the original drafting of the Constitution, may not like it, but decide that they don't want to effectively secede from the country, so they end up accepting a constitution that they didn't like and that under the original procedures wouldn't be binding.
Okay. Judi, did you have anything you wanted to add here?
Yes, you asked if any bad amendments could possibly be ratified. That's what they say. Well, they just have to look at history. Look at we already did that. The 16th, 17th, and 18th Amendments, I considered bad amendments. The 17th Amendment took power away from state legislatures to choose their US senators. So, anyway, there is no amendment on the face of this earth that can restrain a government that ignores our Constitution and usurps power. You can't take away powers from the federal government that the Constitution never granted to it in the first place. What's the amendment going to say? We really mean it this time? At the Convention of States held a mock convention. They handpicked their delegates. They were mostly all Republicans. They were a big percentage of Convention of States sponsors. They came up with proposed amendments that were ideal for them. And after 3 days and voting and deliberating on it, they passed 6 amendments that all expanded the federal government. And that's because nobody can do better than the enumerated powers that we already have. Our government is already limited to the enumerated powers. And the Article 5 was never meant to rein in the federal government for usurping powers. It was meant to correct defects in the Constitution.
Okay, thanks, Judy. We have a couple of questions from the audience, and I'm gonna ask if other people have questions to go ahead and put them in the chat or in the Q&A. So the first question we have is, why must the applications all be the same if there are no limits to what can be introduced at the convention itself?
I can take that. There's nothing in the Article 5 that says that they must be all the same. That has been a tradition that has been followed, that Congress has not called conventions based on disparate applications, but there's nothing written in the Constitution or even in statute that says that. And that's really been a talking point of the pro Article 5 convention lobby groups that are trying to reassure people that our Bill of Rights will not be jeopardized by saying, well, it'll all be limited by applications that say the same thing. Over the last 2, 3, 4 years, as Judi says, the Article 5 convention lobbyists recognize that they're not going to be able to get to 34 the honest way. And now they're starting to say that they'll add in things with entirely different purposes. Preventing the Civil War is a pretty different purpose from repealing Citizens United or imposing term limits or balanced budget or any of that stuff. And yet somehow we're going to treat the states that didn't want a civil war as being part of our program. So it's the changing of the rules that they claim apply is some indication of how determined they are to make this happen. And if they're that determined to make it happen, they'll be that determined to get their way once the convention convenes.
Oh, they're not that different. I'm just kidding. Judi.
Yeah, that's correct. The applications don't have to be the same. That's the point. And the big point is that there's been a false narrative all these years just to get legislators' votes saying they had to be the same.
Okay.
But, yeah.
Thank you. So another question, can states withdraw their applications?
They can rescind their application. Sure, that's what they're doing, actually. In the last 6 years, there's been 6 states that have rescinded their applications. There's 11 states with no applications at all. Hawaii never had one, and the others have rescinded along the way. I think Nebraska may even have rescinded one of theirs. Until a convention is called, and then they can't.
David, anything to add to that?
No, but I think because we are seeing the pro-convention groups expressing ever-changing legal theories about how to count these up, we can't assume that states will have time to rescind once it gets close and starts looking troubling.
So David, while Judy's attending to that, could delegates set up and vote on a procedure that included amendments hanging out there that I think you made reference to?
Sure, convention could time limit any proposals that it makes. It could do any number of things, but the problem is that I don't think that the proponents are going to want that. The special interests that are trying to make this happen are going to want that. And it seems awfully risky to entrust the safety of our Constitution to hoping that delegates who we don't know and who will likely be chosen under the supervision of special interests will be that self-effacing.
Judi, anything you wanted to add to that?
No, that's good.
So another question, what are the names of the organizations in Nebraska and nationally funding the current effort to get states to pass resolutions? I think you touched on this earlier, Judi, but maybe if you have if you can reiterate.
Oh, you're talking about the actual lobbying groups
Yeah.
that are, okay, so the Convention of States Project, Convention of States Action, there's a number of Convention of States groups, is the foremost one on the application LR14. The Balanced Budget Amendment Task Force started the Balanced Budget Amendment, and they kind of faded out, lost funding, and it's been replaced. There's a couple of groups. There's David Bidoff that has let us call, let's vote for a BBA, I think, and then he has another name. And then there's a group that's like CSNDS or something like that, and I always forget what it stands for, and they've got prominent people fronting that one. That's the only ones that come to mind nationally. Wolfpack is pretty much behind the, David may know, there may be more groups in there, but the radical left, I mean, this is bipartisan on both sides, I must say. This is not a left versus right issue. So there are groups, the conservatives against, and there's the Convention of States that are, these supposedly conservative states for. US term limits is the main one, I think, on the term limits group, and the one for the Supreme Court 9 justices. I have a feeling that the Convention of States is behind that, just because a Convention of States person was pushing it in another state who really should have been pushing their own. So I don't know. That one is the most palatable of all, because most people would have a problem saying, yeah, we should have 50 people on the Supreme Court. Although, what's his name, Michael Ferris in 2014, as a co-founder of the Convention of States, was advocating for 50 people on the Supreme Court in order to limit the government. Now Convention of States is advocating for 9 people in order to limit the government. You can make anything out of it.
So just to clarify, Judi, so are there groups that are for this that are basically trying to promote different calls in different states to appeal to the politics there? Is that what you're saying?
Well, they have the same applications in the different states. They're not doing different calls. Some applications get further than others, but the arguments for the applications might change. Like, you don't go in with the Convention of States application in a Democrat state and say, hey, we're gonna, overturn the Citizens United decision with it. But it could, you focus on what they want.
Got it.
That's
David, anything to add there?
No, I think there's, as Judi says, there's the question here is, will there be a convention called or not? Everybody involved, supporting it or opposed it, knows that once it's called, all bets are off and it can do anything at once. And some people look at that and rub their hands, and Judi and I look at that and are horrified. Whether you use, as Judi says, the bait of getting rid of Citizens United or some other left-wing proposal to get the Vermonts and Hawaiis of the world on board, or whether you use balanced budget amendment or term limits or the Supreme Court as a way of getting conservatives on board, is really immaterial. The goal is to be able to tell Congress, we've got 34, let's get that convention.
Oh, one other thing, we have them working together on this. So at for instance, ALEC conservative convention, talking about the Article 5 convention, seminar co-hosted by Wolfpack, because they know that this is going to be one convention. And so it's good for everyone if it gets called. Everyone knows that.
I see. So there was a question, does Nebraska have any active applications? I think you both know I can answer this too, but if one of you would like to take it.
Excuse me, does Nebraska have any active applications?
Active, yes.
Like LR14 for the Convention of States?
No, that are on the books already.
Oh, yeah. What is there, about 8 or 9 of them? Go ahead, Renee.
Yeah, no, I think there are 11. The most recent was from 1979, but we still do have active applications out there. I think we have a balanced budget amendment, and then I have something on polygamy, and anyway, we've got a few others sitting out there. Most of them are incredibly outdated and date back to the I think the bulk of them are from the 1800s.
And I would say the only way, if we don't want to lose the Constitution and our rights to deal with this, is to rescind everything that's there. That's the only way, because otherwise they'll keep grabbing those applications and using them.
And there is a bill that has been introduced in the Nebraska legislature that would rescind those. Let's see. What's the time frame for LR 14? I think this is probably a question for me. Who should we be writing if we have views in this resolution? The time frame we're looking at, it's probably going to come up next week, likely come up on Monday, as we understand. It could be up, I think they're starting at 11 o'clock on Monday, and it could be the first bill up on Monday. So if you have views on this resolution, I would strongly encourage you to contact your senator. You could contact the introducer of the resolution as well. And you can find your senator if you don't know who they are on the Nebraska legislature's website. There's a find your senator button, and you can put your address in there and locate who your senator is, and their email and phone number are there, so you'd be able to reach out to them that way. Looks like there is another question coming in. So what is the number? Oh, what is the number of the bill? Yes, that would rescind, and I'm not remembering that. I'm going to ask Laurel. Do you remember that off the? I am rusty right now, and I cannot remember what that is.
I will look it up.
Thank you. All right. I don't think we have any other questions, so hopefully we will have that in just a minute. Judi, David, anything that you didn't have a chance to say that you were hoping to say today, or any final thoughts?
Renee, can I jump in? Sorry.
Please.
So it's LR 28.
Thank you.
You're welcome.
So LR 28 is the resolution that would rescind our prior applications on the books. LR 14 is the resolution that is coming up likely on Monday, that would enact this Article 5, call for an Article 5 convention that was described earlier. Judi, I think, were you going to say something?
Actually, I had just found LR 28 and I wasn't going to say anything.
David, anything on your end?
I think the key issue here is a runaway convention. How much of a risk is there? And the proponents all say that's not a problem. They say that it's scaremongering to raise that as a concern. And I would just encourage people to respond to that by saying, show me what stops a runaway convention. Show me where in Article 5 it restricts what a convention can do. Show me where it gives the Supreme Court or Congress or anybody else the ability to rein in what a convention does. And ultimately, these arguments against a runaway convention come down to nothing more than trust me. And that's not a very good basis for risking our entire Constitution, that we're going to trust people who clearly are spending a great deal of money for purposes we don't fully understand to get a very, very powerful body to come into being. I might be okay with the idea of an Article 5 convention if you could promise me that most of the drafting would be done by James Madison and that the convention would be presided over by George Washington to keep it on a steady course. But these days we're a very divided country, and I think we all know that if the Liberals control the convention, it won't be a unifying figure like George Washington. It'll be Stacey Abrams or someone like that that will be the presiding officer. And if the Conservatives end up controlling it, it'll be someone that'll be equally unacceptable to the Liberals. This won't be a unifying nation-building thing the way it was in 1787. It's hard for me to imagine a scarier time, a less appropriate time to put our Constitution up for grabs than right now.
Oh, and Renee, remember that the convention doesn't have to run away for the delegates to do whatever they want. They have the inherent right to do that. They represent the people directly. So,
Right,
you know, when they say
which
that
is-
it hasn't run away before.
And
It
which
will
is what
stay.
we saw in the simulation too, right? Took a lot of liberty there. So we have one more question and I'm not exactly understanding it. So we'll give it a minute and see. But in the meantime, I really am grateful to both of you for taking your time today. I really hope that the senators are listening. A lot of the issues that have been raised by them, oh, it will be limited, oh, it will need a large number of states to ratify, it will be very controlled. You know, Congress isn't doing their job, so we need to do this and send them a message and take action ourselves. I hope folks will reconsider their position and inklings to support LR 14. We also are very nervous about what would happen if a constitutional convention were called. So let's see, I'm just going to see. Oh, yep. So I think that is all that we have for today. Again, thank you, David. Thank you, Judi, for being here. To everyone who's been watching the webinar and is interested in this, again, we think that it's likely to be taken up by the Nebraska legislature on Monday. The Nebraska legislature is streamed, so you can watch that if you go to the Nebraska legislature's website. You can click a button, it'll take you to NET, and you can stream that and watch it, or watch it on your TV if you're in Nebraska, to tune into the discussion. Hopefully it will be a good dialogue and an honest dialogue about how this would work and what's at stake. And with that, thank you all for tuning in, and more to come on this very soon. Thanks so much.